Well, good morning, everyone. It's so nice to be here with you today. Good afternoon or good evening, depending on where you are in the world. Welcome to today's Will Work for Food, the New Possibilities Hour presentation. It's October 6th, but what we're going to do today is break on through to the other side. And yes, that is a song lyric, and it was chosen intentionally, and we will find out why shortly. This will be with Marc Harwell and Chad Hatmaker out of Tennessee, two friends and fellow attorneys, fellow mediators, fellow FDCC members from Tennessee. So before we get into the introductions, let's go to what Jeff always calls his favorite part of the program, saying, where are we with the donations? As you know, for the regulars, there's no charge for these programs. They've been going on now for 2.5 years, essentially. And the community, the global legal community is just so generous. It is just amazing. So Jeff, how much have we been told about in terms of donations so far?
Thank you, Jean. Our generous audiences have been just wonderful in terms of making contributions to food banks worldwide in honor of our great speakers. Running total as of this week is a phenomenal $317,275.45. To our speakers, our audiences, thank you all so much. Jean, back to you.
Thank you. That's just so amazing. And if you ever need an example of what one person's thought can do, then this is a perfect example of that as we go down the future, right? Down the roads to the future. So let's get back to it. Marc and Chad have their suggested food banks, and I'll let them talk about that. Natalie will put the links in the chat. The Chattanooga Food Bank, I believe, is one of them. And then the other one, Chad's, I'm sorry, it's skipping my mind right now, but what's the name of it, Chad?
That's all right. It's Second Harvest Food Bank of East Tennessee. And probably many of the viewers are familiar with Second Harvest, as I believe they're in all 50 states now.
Yes, and we've had many speakers who've mentioned their local Second Harvest. So thank you for that. Okay, so let's get going. Let's break on through to the other side. Our two speakers this morning are, as I said, Marc Harwell and Chad Hatmaker. Chad Hatmaker is a member of Woolf, McClane, Bright, Allen, and Carpenter in Knoxville, Tennessee. His primary areas of practice as his legal practice are employment law and commercial litigation, and he represents his clients in proceedings before various administrative agencies, state and federal trial and appellate courts. He's AV rated and listed in Best Lawyers and has accolades all over the place. He is a mediator and has been certified, if that's the right word, as it is, okay, certified as such in Tennessee since 2016. So for the mediators on this call, he is one of us. He's also the employment section chair for the FDCC, the Federation of Defense and Corporate Counsel. Marc Harwell, some of you may remember that he spoke in the past on the 12 pillars of mediation, which according to Natalie is one of the most downloaded and watched videos. So if you haven't seen it, you might go back and watch it. It's great to have Marc back again. Marc is an attorney and mediator in Chattanooga, Tennessee, and he's worked as a trial lawyer for over 30 years. He's tried over 100 jury trials, more bench trials, and he has been serving as a mediator since 2014. So, well, let's see. He's also a senior director and executive committee member of the FDCC, again, the Federation of Defense and Corporate Counsel. And so it's great to have both of you here. Why don't I turn it over to you gentlemen to tell us a bit about your food bank, and the floor is yours. And then let's get going and break on through to the other side. Thank you.
Thank you, Jean, for that introduction. And if you are willing and want to, please consider donating to the Chat Food Bank. That's CHATT Food Bank. And Chad, you might give a shout out for your preferred food bank.
Absolutely. And again, Jean, thank you for the introduction. Second Harvest Food Bank of East Tennessee is my preferred food bank. It serves 18 counties in East Tennessee, including Knoxville, and basically stretches to Chattanooga, where Mark's food bank kicks in. So you can cover what, Mark, half of the state. If you give to one of our 2 food banks, you can cover 2/3, I guess, actually, of the great state of Tennessee.
That's right. So $25 will buy groceries for approximately 75 meals. So it's a great bang for your buck, and it does a great service to our world, thanks to Natalie's wonderful idea. Without further ado, I will go ahead and introduce the break on through to the other side. It's Doors, a famous Doors song, one of my favorite songs, and it certainly seems apropos when we're talking about mediation and the trials and tribulations that both mediators and advocates experience when they are trying to get to the realm of reason and where they're trying to break through impasse. So today, Chad and I have decided we're going to break our topic up into 3 segments. One segment is just getting there, how your pre-mediation preparation. Number 2, getting to the realm of reason. We'll just say getting there. And number 3, staying there. How do you break through impasse? Now, I think I can speak for Chad that both of us are practicing the art of mediation. We have not perfected it. And there are a lot of people that are attending this program today that know as much or more than I do about mediation. So I am asking you, begging you to please use the Q&A feature, use the chat feature, raise your hand. If you have something, a tip, a tactic that you've employed that you've found works exceptionally well in pre-mediation technique and getting people into the realm of reason and getting people past impasse. So starting with getting there, pre-mediation, Chad, would you provide some thoughts that are especially pertinent in your practice that you found are helpful in getting people to the mediation in a proper fashion?
Absolutely, Mark. And I echo your comments that there's so many excellent and experienced mediators on this call that some of this may be old hat to them, but it's certainly a good reminder to all of us. And if it's news to someone in the group, then hopefully you will be able to use it effectively. Before I became a mediator, I would notice that certain mediators I used would call me ahead of time. And I had submitted my statement. And so sometimes I wondered, why are they calling me? I've set forth the information they need. And then after it happened for a while, I realized that the good mediators make those phone calls before the mediation. And why do you do that? Why did they do that? Why do I do it now? Mark, why do you do it? Why do as mediators we make that call? Well, it gets you the rest of the story, as the great Paul Harvey used to say. Hey, what's going to really happen in that room? What obstacles do we have to overcome that we might not otherwise be aware of and that you're not going to put down in paper? What candid comments do you want to share? Very effective from my standpoint in getting the rest of the story so that I know what I have to work with when I go in there, and it will identify for you, usually further identify for you, and it does for me, hey, what are the leverage points, right? Where am I going to be able to push? Where am I going to be able to, what do I have to do to get the parties in the right frame of mind? So I found that extremely effective, Mark. The other thing that it does for me, in addition to what I just mentioned, is there some other piece of information you will get in that call that you were not expecting? A quick example, a couple of years ago, I was mediating a sexual harassment, sex discrimination, retaliation case. There were multiple, I believe at that point in time, it was just at the EEOC, so multiple charging parties. And I'm talking to the plaintiff's lawyer, and he says, hey, I'm going to want to call witnesses for you to talk with during the mediation. And I chuckled now, and then I probably didn't chuckle, but I thought, well, I'm not the judge. I don't really want to hear your witnesses. But that would have taken me flat-footed if we'd waited the next day. Instead, I said, okay, I'll tell you what, let's do. You have them available. Let's see how it goes. And if we need to talk with them, then that's what I'll do. As it turned out, we didn't need them. and it was fine. But the important part is he felt he had been heard, and I would have gladly listened to his witnesses, even though, as everyone on this call knows, it's not like, I was the judge of credibility of the finder of fact. So something unexpected like that, you can get out of the way when you make that pre-mediation phone call.
Yeah, and I've also found that just having the conversation helps me pick up on tone, and tone I think really matters. The more I listen and hear the level of the dialogue, is it shrill? Is it loud? Is it really passionate? Also helps me figure out how far along are you. Now we can find out, they can tell us when the trial date is, and they can tell us what depositions have been taken, but they don't necessarily tell us what information they're withholding. And they may not even tell us during the pre-mediation call or even during the mediation, but it's helpful for me to know, is there some crucial bit of information that's being withheld? And if so, why? And is there any way that that will be disclosed over the course of the mediation, if not in advance of the mediation? I had one not too long ago, and there was a video that was taken. The video, I could tell from the mediation brief, had not been disclosed to adversary counsel. And over the course of the conversation, pre-mediation, I was able to talk to the attorney and help the attorney understand how crucial it was for that video to have been shown to adversary counsel yesterday, and did go ahead and disclose it, and everything blew up in advance of the mediation. But since they did it in advance of the mediation, the blow up occurred not during the mediation, and level heads were able to prevail. Tempers were calmed down, and we were able to get actually started in the mediation with a more civil tone. So I think finding out what's being withheld, can it be disclosed without harming the case, without harming position? Should it be disclosed? And another one that I think is crucial to the pre-mediation is dealing with really tricky issues, such as insurance coverage and liability issues that are at play. I found it extremely difficult to handle the mediation of both a coverage case and a liability case in one setting. Chad, your thoughts about really tricky issues, pre-mediation and best practices?
Mark, I think the coverage liability issue is one of the most tricky, and I know you've had a lot of experience with that one. Another one I would say that can be, it's not as tricky, but can be somewhat tricky, and you're certainly going to have to give some thought to how we're going to play it out, is when you've got multiple parties involved and you're going to have to determine, all right, how are we going to go about this during the mediation? I mean, we have multiple defendants. Are they aligned? Are they going to be battling it out against each other, pointing the finger at one another during the mediation? And your pre-mediation homework will help you assess that and determine how you have to proceed once the mediation starts.
I think Chad pointed at me because it was not too long ago that Chad actually served as a mediator on a case where I was the advocate. And to say that tempers were running high on both sides would be an understatement. And so I think it helped Chad to know in advance what kind of tone he was dealing with from a person who's frankly extraordinarily patient most of the time. I wouldn't be a decent mediator but for that patience that I have. But when you're sitting in the role of an advocate and you've got a client that you're passionate about and a story and a message that you've got to zealously sell, it really takes the mediator's, persistence and patience to even tone it down with this, I think, reasonable person. Chad, you can disagree.
No, I agree. I agree with that. And to that point, when you are dealing with someone, one of the attorneys who does mediate, it's important for you to assess, okay, know that their role is going to be a little different, right? When you go in and you're a mediator, but you're an advocate during that process. And so you have to assess that. And the other thing from the pre-mediation calls, and we've sort of touched on this, is is, and Mark, you hit it really well with the tone that you're going to catch. You'll know in those calls, typically you'll know whether are the attorneys going to be, I would say there's three roles they can take, right? They can be just an advocate and not either be positive or negative for settlement. They can be positive for settlement because they believe it's in their client's best interest. And I mean, let's just call it, we've all seen it. They can be an impediment to settlement for whatever reason, financial reasons, whatever it may be. And you'll be able to assess that pretty quickly in the calls and certainly when the mediation starts. And you have to determine, look, how am I going to effectively mediate this case? And within my role as mediator and not crossing it, essentially work around counsel for one of the parties because he or she is going to try to do everything they can to get in the way of the settlement, even if it's in their client's best interest.
Right. Also, pre-mediation, some of this is going to be obvious to this experienced audience, but I just feel like it, maybe there's a nut or bolt that can help somebody on the call. One of my favorite apps to use pre-mediation is a liquid text. I don't know how many people use liquid text. I find it to be extraordinarily helpful for me to get all the materials in one place. I can highlight it, I can pull out, drag and drop, and it lets me speak very effectively to counsel for both parties because they know that all of this documentation is at my fingertips. It's all highlighted. And so I can talk to them in real time, just back and forth, challenging them and engaging. And another technique I love to use from that is summarizing. Now we're getting into the start of the mediation, but if you don't do that homework in advance, then your opportunity to really summarize key points, key positions, key facts is limited. And I do think that I love to use summary in a lot of cases because it lets me automatically connect with a party that they know I understand the case. It's more efficient if I can bring it to summary rather than rehashing it all. So I gain some credibility. I gain some, I get credibility, and you've got credibility is just absolutely crucial at every stage of the mediation. And then I found that summarizing technique has been very efficient helpful for me. Chad, any other points that you want to make? I could speak briefly about some techniques involving coverage disputes and liability disputes, or I could call on Jean Lawler to jump in on this and give us her thoughts about how to handle that really tricky matter.
Well, thanks.
She's one of my favorite. I can't help but call on her.
Well, for me, I have found both when I was in practice and as a mediator now for just about 6 years, it's so much better to do the coverage mediation ahead of time, whether it's with the insureds or just with the insurers or with the insureds and insurers, if the insured's going to be putting something in, just to arrive at some parameters within which then the defense counsel, because this would all be for the defense side, within which the defense counsel can then operate. The defense counsel's already provided the carriers and their client, the defendant, with recommendations or thoughts as to judgment potential or settlement value. And if the group, the big group, and sometimes it's really huge, but if they can agree going in on percentages or portions that they'll each take up to even a certain dollar amount for settlement, then that gives the defense attorney something to work with, and then makes the liability mediation, I think, be more focused on the plaintiffs and the defense and the liability issues. And if it takes more than whatever they've all agreed upon as the amount that they're willing to go up to based on these prorations they've agreed to, well, then that's fine. Then they deal with that then and there.
Right. So kind of a cost share and funding agreement in advance of the liability mediation.
Yes.
Yeah. All right. Sarah, do you have your hand raised? I see a hand raised, but I'm sure she'll jump in when she's ready. So let's now move into starting the mediation. We've talked about how you get there, some fundamentals. I'll start off with my pet peeve, and I think it might be the pet peeve of a lot of mediators on the call is backsliding. In advance of the mediation, plaintiff makes a demand, defendant makes an offer, you start the mediation, plaintiff wants to go above the last demand or defense wants to go below the last offer. And it just, anyone had a good experience with that, raise their hand. All it does is increase the vitriol, raise the tone in an unhelpful fashion. And I have frankly just stopped allowing it. I've just started drawing a hard line in the sand, and I've said I'm not going to be a part of silliness, and I'm not going to be a part of anything that I think is unproductive. I've never found it to be productive. So unless you have some really, really good reasons for the increased demand or the lower offer, then I'm not going to do it. And so far I have been challenged, but I've held firm, and it has always worked. So knock on wood, and hope that trend will keep going. Chad, what's been your experience with backsliding, and then some other issues that you'd like to discuss in terms of getting the parties into the realm of reason?
Mark, certainly, I take the same approach that you do on backsliding. That's my number one pet peeve. And I just tell people, look, we're not going to do that. And try to get them, you can get them off the ledge of that. Usually they'll at least go to what their last offer was, which is no movement, which is not good, as we all know, but it's certainly better than going the other direction. Another pet peeve, I would say, when getting started, and this is something I would submit, look, one of the things we've got to be careful with when you are there with an attorney and his or her clients is, I'm going to say it like this, not showing up the attorney. A better way to say it might be not making it look like the attorney does not know what he or she is talking about. Specific examples, earlier this summer, I mediated successfully, but this was a big impediment, a class action under Title VII. And literally in the room with the plaintiff's attorneys, who are very experienced and know what they're doing, very good attorneys, they've got 8 of their clients, and then their opening offer is more than their best day in court. So they're not backsliding, but they're it's not hyperbole to say it's more than their best day in court. There's damage caps under Title VII. We know it is more than their best day in court. And so I have to sort of diplomatically say, but I said it, hey, that's more than your best day in court. Yeah, but we just kind of want to send a message. And I said, well, I think you're going to send a message. And sure enough, they did. And 6 o'clock, they're getting into the realm of reasonableness. And an hour later, we get the case settled. That's another big pet peeve, Mark. And I think we've got to be careful as neutrals not to overstep there. But I also don't think we're doing our job as neutrals if we don't say, at least as diplomatically as we can, let's try to go elsewhere, because that's probably better than, the jury's going to give you anyway, or more than what the law allows, because all that does is going to slow things down, and it might terminate the mediation prematurely.
Yeah, it's a lot about tone. Back to tone again for me. That I always tell the parties, you speak and you message in 2 fashions. You message with your story, and you message with your number. And, a really loud number, be it exceptionally high or exceptionally low, is shrill. It's yelling, and yelling in a shrill tone does not beckon negotiation. It doesn't beckon reasonable stances. It doesn't draw a reasonable response necessarily, because you just basically hit somebody in the nose and you expect them to take it and respond not in kind, which is a really high expectation, right?
Absolutely. Very difficult.
I also think, I run a lot of marathons, and I kind of liken it to what I found in marathons, no matter how well I'm trained, in the end, the last 6 miles comes down to energy management over the course of the whole 26-mile race. It's really energy management. And if you've used up all your energy early on, then when you're actually at brass tacks and you're actually at that, in that realm that is where settlement is achievable, it's possible, people can see it, there's hope, then that's when the energy really, if you've expended it already, it leaves it flat.
Yeah, it really does, Mark. And sometimes and I'm sure the experiences are maybe somewhat different. I'm hopeful, but I suspect probably throughout most of the country, the mediations we do, and Mark, this was actually not the case in yours recently, but what happens, the plaintiff asks for the moon and the stars and the defendant offers, next to nothing. And so you have to manage that expectation right out of the box. And to your point of expending energy, so much energy can be spent early on when, particularly if it's a personal injury or an employment case where you have a individual plaintiff, not a commercial case, but an individual plaintiff who's going to be emotional, is going to be wrapped up on the numbers. They'll spend so much energy right out of the box when the defendant's offering them $5,000 or $10,000 and they're asking for $500,000, that it's so hard to keep them invested in the process all day. I have taken to saying in pretty much every mediation I do with an individual on one side, sometimes I say it in the defendant's room, depending on the experience level and who I'm dealing with, but I'll tell the plaintiff, look, I need your patience. I mean, this is going to be a long process. We didn't get here in a day. Rome wasn't built here in a day, and this is going to take a while. It just does. And then I say, I want you not to focus on the first offer. I want you to focus on the last offer. And sometimes I'll even say the first offer, it's not going to be what you want, most likely. It might even upset you, right? Don't be upset. Don't be offended. It's part of the process. Don't focus on the first offer. Focus on the last offer. And I have found, particularly when they've got a good advocate with them who can reinforce that message, I feel like that keeps the plaintiff, who typically, but not always, is going to be the more emotional of the two parties involved. It keeps them from expending so much energy early on. I'm frustrated, I'm insulted. They offered me $5,000 and I've got all these injuries, or I've lost my job, or whatever it may be.
It's what we call the process, right? Everyone on this call has probably talked about the process. And I think that the reason we talk about process so much is it does take some time and it does take some energy to be expended, to be wasted, so that people can actually get into the logical, right?
Yes.
Speaking of logic, so one of our favorite presidents is Lincoln, and I did not know this about Abraham Lincoln, but not only was he a great lawyer, and politician, but he was a great student of Euclidean geometry. And you might wonder, why did he spend a lot of time studying Euclidean geometry? That's what his partner asked him, and he liked it because it made him practice logic. And he told his partner, he said, I can't be the best advocate possible unless every note and every sentence and every paragraph in my message is supremely logical. And the more logic that I can bring, the more truth I can bring to bear, the more effective I can be for my client. And I like to talk to advocates about delivering their message in both number and dialogue tied to some logical basis. What is the reason for it? Why that number? And you did that same thing, Chad, when you effectively called counsel out when their number exceeds the caps, which just makes no sense. And I had the same experience a couple months ago where everybody knew what the policy limits are and had been demanded, and lo and behold, they wanted to start off with policy limits plus $500,000. I'm going, this is confidential. You've already set your record by letter. You've already played that card. You don't get to play it in the confidential mediation. That's not going to come out. What's the point? What's the logic to it? And we're able to get them to come actually down below the previous demanded policy limits. So tying it to logic, I found to be very helpful. Anything else you want to talk to our audience today about in terms of getting into the realm of reason? Perhaps some bracketology, Chad?
You know, bracketology, and I see we had a question popped up on the chat where someone inquired about the use of anchoring, and I'm assuming, although assumptions are dangerous, but that's very similar, or I think it's just another name for bracketology. And so bracketology can be very frustrating. What I have found is what it frustrates me is the attorneys get in there and one of them gets, despite me saying be patient and they know all that, they get frustrated 2 hours in and they really want to move it along. And so 2 hours in, they're like, let's do brackets. And that, it doesn't work. They're too far apart. Often you'll have, or I'll have a read on the room, and you will as mediators, that you'll know we may never get to brackets today because they're not going to go below X, or not going to go above X, and you're not going to go below Y, so we're never going to get there. I try to postpone the brackets as long as I can, and if we can do it without it, that is my strong preference. And I think generally, in the majority of the cases I've mediated, we have done it without brackets. Sometimes brackets can be effective, and where I've found them to be effective is the parties have gotten into an area where there is a gap there in the middle where you as mediator believe there's a pretty good shot we can meet in the middle or pretty darn close to it. And they've moved in the area where you can bridge that gap. And at that point in time, if the parties want to use them, I will go forward with it. I don't know that I have ever suggested it because, again, I think they tend to get in the way, but I will allow it at that point in time and have had success when the gap has been bridged closely enough. But the big takeaway, or big, I guess, concern from my standpoint is wanting to use them too early and wanting to use them when there's no bracket that's ever going to exist because they're just too far apart. That would be my take on brackets. What's your experience with them been, Mark?
Well, I use them. They're a helpful tool. I think I find them most helpful when the parties are. I'll use Gene's analogy when they're dancing, but they're dancing really, really far apart, and they're feeling each other out really, really far apart, and so you're getting into this tit for tat that's still outside the realm of reason, and they're feeling each other out, and they're looking at midpoints that make no sense because both of them are still outside the realm of reason, and tempers are flaring, people are getting frustrated. And so then I'll often recommend a bracket just so that we can find out, is there hope? I really do think, I've used this word now twice, hope is important to mediation. I think the parties are looking to see, is there a chance? And, they start off the mediation and it's Christmas Eve, all the presents are going to come in. And then there's the downside, there's tears, there's frustration, there's anger, because there's a realization that Santa Claus is not coming today. But also the Grinch isn't necessarily coming today. There's a possibility for us to reach a compromise. And so if you'll give us give a bracket, and it can be broad, but just let them know that there is some opportunity for movement in a realm of reason. And if you get a bracket in response, that's not necessarily a bad thing. See what it is and see how long is the bridge across the divide. And I have found them to be helpful, but there is oftentimes pushback because people don't want to telegraph where they're going, even though they're on that journey, whether they like it or not. So it's a helpful tool, I think, to get into that realm of reason and explore that realm of reason, I think. What other methods, Chad, do you like? I know that you like to be creative. You like to think outside the box. Give us some thoughts about some creative techniques that you've used to get people started in the right fashion and moving along in that early stages of the mediation.
Yeah, moving Mark outside the box and by that, I'm thinking, okay, how can we potentially get these parties to view this differently, or what else is out there that might get the frame of mind to move towards one where we might just settle this case today? In employment cases, sometimes the non-economic terms, rarely are they more important than the economic terms. Sometimes they are, but often they are very important. And so it may very well be of value to that plaintiff to get a letter of recommendation, even if it's a watered down letter, but a letter of recommendation on the company's letterhead. It may be important for the plaintiff to get an agreement from the defendant that you'll remove, or in response to reference requests, you're either going to give a neutral reference or you're not going to disclose that you terminated me because you believed in your mind I was not performing at an adequate level. So non-economic terms in the employment cases can be effective. They can be effective in personal injury, the apology. We've all seen the apology, right? And it's can be very powerful, even if it's a non-apology apology. And by that, I mean, you're not accepting liability, but you're apologizing for the harm that the plaintiff has experienced. Those can sometimes really help bridge the gap when the economic terms otherwise look to be insurmountable. On a business case, I think it can be, if you can get the parties thinking this way, if it's truly a business case and it's realistic, and it's not always going to be realistic for a number of reasons, but if there's an opportunity for these parties to structure a deal where they settle this case, but they do it as a business deal, or it has business terms where they will do business in the future, that will really change a lot of heads, because then one party's not thinking I'm paying for litigation. They say I'm paying for litigation and to buy out my risk, and for this, what I'm getting in return. Am I buying real estate? Am I buying products? Do I have favorable terms going forward with which I can continue to do business with this company? Again, I think we all recognize those are not going to fit every case for a number of reasons, but when they fit, when that's a possibility, I found that to be very effective, Mark, to breaking down the barriers and getting towards a deal, getting to the other side.
Yeah, it's a wonderful thing in commercial litigation, commercial mediation, when you have two really savvy business persons and they don't want to be in litigation. If you can get them to start thinking about how a win-win can be created outside the litigation or because of the litigation, then progress is often made, and it's a wonderful thing when you see the mind start churning about how do I think beyond this litigation? How do I think beyond my anger, beyond what he or she did to me, and start thinking about, wow, okay, it's water under the bridge. We can move on. We can make money. We can prosper. We can do well. All the good things that can happen when people lay down their swords and start working anew. Any other final comments that you want to speak to, Chad, in terms of getting into that realm of reason?
Mark, let me follow up on something you commented on earlier that I thought was a really good point that needs one more hit on it, is tying offers to something tangible. That can be very effective in both rooms, but I find it typically to be a little more effective in the plaintiff's room. Let's give an employment case for an example. If you can say, again, let's say the plaintiff wants $500,000. Well, if the offer is $45,000, that's nowhere close to $500,000. But if that also equals the 1 year salary for the plaintiff, that can be very effective in getting he or she in the mindset of moving forward. At that point, they don't, not always, but they don't tend to look at it as, oh my gosh, that's $455,000 less than what I asked for. They will often look at it, if presented correctly, and they have an advocate that's going to be objective and not be an impediment. They will often look at it as, I've been heard. They're offering me a year's salary and they're hearing me. They're paying attention to me. This is important, and let's negotiate from there. And so I think that is an important factor is anytime, and a lot of times, look, at a certain point it degenerates. We have all seen it, right? The offers will start and they're tied to something and then that'll fall apart. But as long as you can keep it tied to something for as long as you can do that, I think that's effective of getting buy-in from the parties to hopefully get them to the strike zone or the ballpark.
All right, let's move into breaking on through to the other side, getting past impasse. What are some techniques you've used, Chad, that you found most effective when you've been at it and that sixth sense comes to bear and you really start to feel it, that this isn't going to happen. I'm losing it. I'm losing them. This mediation is going to fail. We are approaching impasse. What techniques have you employed to get people past that breaking point?
One, Mark, that has been effective for me is the mediator's proposal. Sometimes when the parties are, and you and I have talked some about this, and I know you'll probably add to it. The danger of that is when the parties want you to do it too early and you don't go there, of course. But when you get, as you said, your sixth sense, that this thing is not going to settle, but it might because you've established good rapport with the parties and you have a sense of where the tipping point might be. And by that, I mean, okay, the defendant doesn't want to go there, but they will to settle the case. And the plaintiff doesn't want to go there, but they will to settle the case. The mediator's proposal that is set forth, I've had very good experience with, certainly recently. I think I've had a number of cases that have resolved that way. I would certainly like to do it that night of the session. I tend on the mediator's proposal, and I have done them the night of the session. But when I think parties are at their wits' end and we break, I have done it in the days that follow by email, and it has been effective as well. I prefer to do it that night. It doesn't always work out that way, but that has gotten them over the top and breaking on through to the other side in my experience. How about you? What is your sort of go-to move to get parties past impasse into a settlement?
Well, I'll dovetail off of your point in terms of the mediator's proposal. I am not a fan of them as a rule. I use them sparingly, and the times I've used them sparingly, they have worked. I think it's because I think the timing really has to be right, and the bridge cannot be too far. I had one where it was that the parties were $600,000 apart, and I went into one room. They said, "Well, you give us a mediator's proposal," and I went to the other room. "You give us a mediator's proposal." And I look at both of them. I said, "I'm not giving you a mediator's proposal. You're not working. You're not trying. Neither side is trying. Y'all are $600,000 apart, and you want me to do the work that you should be doing. I'm not going to bridge that divide for you." And you know what would have happened if I'd given them my mediator's proposal when they're $600,000 apart? One party would have been angry with me. I don't know, maybe both parties would have been angry with me. The bottom line is I'm inserting my judgment. I'm inserting my risk reward judgment for their risk reward opinions, final thoughts. So I rejected it. I didn't do it. The mediation failed. About 8 months later, they called up and they wanted to come back to the table. And they did the hard work. Still came down to a mediator's proposal, but they were only around $30,000 or $40,000 apart at that point. I gave them a mediator's proposal and it worked. So just to highlight your point, timing is everything. The bridge cannot be too far, and inserting my judgment for their risk reward is just something I think I should not do as a neutral. It's funny. Even experienced advocates can lose sight of the goal because they're in the trenches. They've been fighting. Now they're still fighting. And they just don't know how to take off the uniform or the helmet and put down the sword and start working as a negotiator because the level is still so high. So if I can get them to refocus the goal, asking them the right questions, help me. One of my favorite questions is starting off with, help me understand. Help me understand what is your expectation? If you were on the receiving end of that number and that message, what would be your response? Is that number, is that message designed to get you to your goal? Can you think of a more productive move? Can you articulate another perspective? Does that get you closer to your goal? If I can just ask the right question and truly listen to them and truly get a sense of why they are taking that position, then it will help me, I think, be a better negotiator with them and for them. If I can just get them to reflect and respond logically. Chad, your thoughts?
Mark, those are all excellent mediator questions, and I'm a huge fan. I know you heard it from me recently. Help me understand is one of my favorites. What's the message here is another one. I think those are wonderful. And I also think, and this sort of goes back to the mediator's proposal, but an alternative to that, which may get you to the same place. And it involves asking questions as well. As when you think they're at impasse and you've hit that 11th hour, focusing back through effective questions such as the way you just phrased those on something we all learned when we did our mediator training, whether it was 1 month or 6 years or 10 years ago, focus back on what's your best alternative to a negotiated settlement and what's your worst alternative to a negotiated settlement. And a lot of times I've had success with that when one side's ready to throw in the towel, but then you recalibrate and focus on the fact that if they do, litigation is going to go on for your trial date's in 6 months, and then there's going to be post-trial motions, and there's going to be the appeal, and next thing you know, it's 2 years later, and even if you win, it might be reversed. You all know the drill on that. That sometimes will cause the parties to re-evaluate their quote lines in the sand, close quotes, and come back around. But effective questioning and positioning, like you just demonstrated, is the key to effectively explaining to them and helping them focus on what are their best and worst alternatives to cutting a deal tonight.
You know, and that one you handled for me when I was the advocate, you did a great job of getting both sides to kind of hone in on the gray and work on the uncertain. And I think that's helpful in getting past impasse. If you can truly and logically create that environment of uncertainty, which frankly should be so much easier for us to do now, given the uncertain world that we live in. I had a case that did not resolve. It did not resolve. This handled it last year, and didn't resolve because the parties, the trial date was set. It was only 8 weeks out from the mediation. We'll go try. We'll go give it a shot. That case has still not been tried. And I hear that the trial setting is out into 2023 now. So again, in this most uncertain COVID world, where we really don't know truly much of anything anymore, it seems like to me, getting the parties to focus on the moment that they can actually take control and get a certain result can be a wonderful thing. It can be that win that you're trying to create. It's the only opportunity they have to create their own certainty, right?
Absolutely right. I do it. I know you do it. I'm sure many on the call do as well. This gives you the rare opportunity to fashion a remedy of your choosing. You know, you can include things as part of a settlement here that you can't get in court. And of course, sometimes that can be a stumbling block, right? When a party insists on something that a court can never give them. But if you're doing your job, you're able to explain to them, look, don't wrap around, don't hold up on that, because that's not something you can get even if you go forward and win. So that can be a double-edged sword, but that can be effective to help them. Hey, this is your opportunity to fashion the remedy the way that you want to fashion it.
Right.
Go ahead. I was going to say, we're touching on one other thing that I know you and I talked about as a way to break on through the other side. And I would say this one has to be, you obviously in all these, use your discretion. This one's probably the most limited because in a lot of cases, it just will not work. It won't work for a number of reasons. They might fight. They might get into a screaming match. Any number of things could happen, but in the probably somewhat rare case when you can bring the clients together at the mediation, you have to have a lot of trust there with who you're dealing with as clients. You have to have a good rapport and a lot of trust with the lawyers, probably limited to primarily to business disputes, but not necessarily. You put the parties in the room for a few minutes with the mediator in there, right? Somebody probably needs to be in the room. And when I've done it, I've been in the room. It's amazing how effective that can be. And sometimes it's not effective. Sometimes one side's like, look, I hear you, I just can't do it. And you're done. But a lot of times they're able to talk business person to business person, and they're able to get it resolved in that few minutes when they sort of, Mark, to your point, it's not that they let their guard down so much, but they talk like business people and not like litigants. And so limited, but I think worth mentioning that when that's a tool in your tool belt and you think you need it to finish off the case, I would encourage you to use it.
Yeah, you don't have to do it at the start, do you?
No.
Frankly, I've gravitated to giving pushback on the start because I've got to learn as the mediator really what the true tone is. And maybe I need to they need to shout it out for a while. They need to get to the point where they're actually more toned down. And then it seems to be more suitable in the appropriate circumstances with the right people to have a level conversation eye to eye, where you can see the body reaction. You can see the reaction and have an opportunity to just better communicate. So I'm glad you raised that point because I do think that is can be an effective tool in the tool belt, as you said so well. So I guess any parting thoughts or final comments that you want to make before we turn it over to our audience for any comments and questions that they might have?
I think we've covered it. I'd love to hear from this esteemed audience and get their input. I guess the one thing I would go back to that I always have to tell myself is you got to be patient. I always tell the litigants that and the clients, the attorneys that, but it's true for us as well. We've got to exercise that patience and not get frustrated, and we'll get frustrated, right? I mean, we're human and it's going to happen, but if you can practice what you preach. In my experience, unfortunately, parties don't get in the strike zone or the ballpark until what? Sometime after 2 o'clock, sometime after lunch, and then it may take you another 4 or 5 hours to get it done. But practicing the patience has been key and is a good reminder, I think, for all of us.
Yeah, the 3 Ps: preparation, patience, and offshoot of patience, persistence, right?
Absolutely.
I'll tell you one quick story. I had a case I mediated a while back, and one of the advocates was had been a friend of mine for 50 years. I've known him since I was 8. And I was in the room at about 2 o'clock in the afternoon, and I did not know my friend anymore. I realized, I said, who are you? What has happened to my friend? Because you're not there. I said, what we're going to do is we're not going to talk about this case for an hour. We're going to go have lunch and we're going to talk about anything but this case. And when I come back in an hour after I've fed you, I want to find out, I want to meet my friend again, and I want to have an engaging discussion about where this case is going to go. My friend came back after an hour and we got the case resolved, but it is that persistence and patience and timing that matters, right?
Absolutely. Have you, just out of curiosity, before we throw it out to the ground, in the last 2 years, have you mediated a case where you started with a joint session and the parties actually engaged? So in other words, at the beginning of the mediation?
No, I have not. I have not. I just don't like it. I need that time. I think the parties need the time for me to understand it and for them to burn it up. And then I have had joint sessions further into the mediation that have been productive. Just the risk for me when all I've read are the briefs, and had a conversation, hopefully had a conversation with counsel on the phone. But starting it out that way, I mean, I actually had a case where I was an advocate a few years ago, and our federal magistrate gave a speech at the ends of court. And I'm sitting there listening to this federal magistrate talk about mediation. And I look at my table, I go, he's talking about me. And the story is that I was defending an employment case, and I had, frankly, I just done a really good job cross-examining the plaintiff in the deposition. It was a really emotional case for him, and the attorney felt like he had to showboat for his client, and he was standing over me and my client, and it went on and it went on. And thankfully, I had told my client in advance. I said, I've got worries about this attorney, and I think I think we can expect only bad things from him at the start. Can you take it? Will you stay in there with me? And thank God I had done that, because I, at one point, all just about stood up and walked out. The magistrate told me in confidence that in the end, he was surprised I didn't. I'm glad I didn't, because I did a good service for my client. But that's just a horrific example of something that no one should have to experience. And it's bad advocacy was what it was.
Yeah,
but we got it done, and the client was happy in the end.
I agree with you. I have, and it's almost like it's become taboo among the bar that no one wants to do a joint session. I think at the beginning, I think part of that is fear that it will start it off on the wrong foot, and sometimes that's founded, or well-founded. Sometimes I think, if I'm being candid, they're like, look, I don't want to spend the time to prepare an opening statement. I'll just let you get in there and do your work. I get it. A joint session, if done appropriately, and I noticed we had one comment in the chat that said, all of my mediations, the parties are together all the time. Certainly, I know the practice in Tennessee is, if you're together, generally the practice is, if you're together, it's joint session only at the beginning, then you're apart. Mark and I tend to do, if we do joint sessions, tend to do them later. I found them to be more effective. An opening joint session, if done correctly, can be great. It just hasn't worked, at least in Mark and our neck of the woods, and in border states as well, where I know we both practice and mediate. It's just not the approach that we see much at all. I know Robert's got his hand up, and we need to kick to him. But I also saw we had a question asking about, are we doing many online mediations? Certainly, I did some when COVID, of course, is still around, as we all know, much to our chagrin. But when it was more of a factor in our day-to-day lives, I did several by Zoom. They worked well. It's still my preference to do them in person and have the parties there in the room. But it was, in my experience, effective, provided you do all the types of things that we're talking about today and treat them the same way. You have the pre-mediation phone calls and the like.
Hey, we're down to 2 minutes, and Robert Palmer is patiently, using your 3 Ps, patiently waiting with his hand up. So Robert, do you want to go ahead and ask your question?
Sure. Real quick, first, in Florida, we're still doing most of them by Zoom. The question, mine was on anchoring, but mine is more from the standpoint of the psychological idea that I'm going to start really, really low to send the message, even with an unrealistic number, as opposed to the brackets. And I'm trying to think of I'm asking for some insightful ways to tell carriers, nobody's taking 5 cents on the dollar, and to tell plaintiffs to get into the ballpark, because they both think, well, this could happen. And you say, yeah, but it's outside the bell curve. Y'all's insight would be very helpful.
Taking a real, at some point, I think the mediator has to really take the reins. And that's not saying that, it's my way or the highway or anything like that, but it's really talking candidly and with conviction from a knowledge-based position. That is not in the realm of reason. And let me explain why I believe that to be so. And then you tell me where I'm wrong. Because if I'm right, then help us get into that realm of reason. So, I'll give them my perspective after a really considered reading of the briefs and a really considered discussion of the facts and the circumstances. And then I throw it back to them and say, but help me understand where I'm wrong. What am I not getting right? Chad, what are your thoughts?
I agree with that approach and Robert, yeah, I mean, I'll obviously we've got a duty to take those unrealistic offers out of the outset. And I will usually say something like, all right, like Mark said, I will take that, but I don't think that's going to really be productive. We'll say the right things. And as Mark's just established, after you establish rapport, I have said to people, and this usually later in the day, did you come here today to settle the case or not? Because if you did, that's not, I'm just telling you, that's not going to work. It's not going to be effective. And let's think about another way to approach it. And if you've done your job and you've established that rapport, sometimes that will allow them to go, okay, you're right. I shouldn't offer 10 grand when I know the medicals are 50. So how do we get moving beyond that?
Thanks.
Yeah.
Thank you. Yes, thank you, gentlemen. Thank you, everybody. On that note, it is the top of the hour. So we're done for today. You can watch the video on this. And as somebody commented in the chat, those 12 pillars are worth a watch as well. So thank you all so much. Bye-bye. See you next week. We've got Bruce Edwards coming next week, and he is amazing. So don't miss it. It's not to be missed. Bruce Edwards. Thank you so much. Bye-bye.
Thank you.
Have a great day.
Have a great day.
Bye, everyone.
Bye.